Hi there, I'm James Dapachi, and this is Coffee and a Case Note. Team, today we're going to talk about the law relating to offers that are sometimes called Calderbank offers that get exchanged between parties to litigation. And before you fall asleep, let's get into the factual backing here to see if we can understand the position together between ourselves. So we have a plaintiff and we have a defendant. They get into a dispute. There's a piece of what we lawyers call litigation. The plaintiff wins, the defendant loses. And the plaintiff is ordered to receive from the defendant an amount in excess of $1 million. And there's a comment made in the reasons for judgment from the initial judge that says, well, it looks like the right order is an order for ordinary costs being paid by the defendant to the plaintiff. I can pause you there for a moment. What often happens in litigation is what we lawyers describe as costs following the event. So we sometimes say whoever wins gets their legal costs paid. And so that's sort of on the basis that, well, you lost, so you shouldn't have really sued me in the first place. And so you should pay my legal fees because it was unreasonable for you to sue me. It's sort of broadly speaking some of the public policy reasoning behind what's going on. Now, there are these types of cost orders. One of them we loosely call an ordinary cost order. And this is the type of cost order the plaintiff gets in this case. And an ordinary cost order might be thought of as somewhere in the range of like 50, 60, 70% of the legal costs that a practitioner might incur. And so this is the position the plaintiff is in. They've got their $1 million+ bucks and they've got their benefit of an ordinary cost order that might put them back in the black of sort of 50, 60, 70% of the legal costs they've incurred. Now, there's an area of law relating to Calderbank offers and also offers of compromise pursuant to some relevant rules that we're not going to discuss here, that if a person in litigation makes an offer pursuant to the tenets, in this case called Calderbank, and you'll be able to cite the citation better than I will, then that can be thought of as an offer to compromise proceedings. If an offer of that kind is rejected or allowed to lapse in certain circumstances, and the court decides to exercise its discretion, then the court might make an order that the person receive not an ordinary costs order, that 50, 60, 70%, but what we sometimes call an indemnity costs order or a solicitor client costs order in the range of kind of 80, 90, 95%, a really juicy amount of costs. And so as you might imagine, in a big piece of litigation, the difference between 50, 60, 70% your ordinary cost order and sort of 80, 85, 90, 95, a big juicy amount of your legal costs can easily be in the hundreds of thousands of dollars. And so when parties go sending these Calderbank offers back and forth, it can be a pretty important and resonant issue in the litigation, as it was here. So the plaintiff wins this litigation and says, yep, great, we've got our ordinary cost order, but on this date in kind of June 2025, we made this offer to settle for about $1.7 million. We made this offer, a couple of other conditions, and what happened is that pursuant to the tenets of Calderbank offers, the outcome of the case means we should get our costs on the indemnity basis or the solicitor client basis from the moment this offer lapsed. And so that's essentially the issue the court is forced to deal with here. There are a couple of other offers made after this first one that are in similar terms. They're kept open for a shorter period of time. We're not going to spend a long time thinking about those other offers because the plaintiff leans heavily on this first offer. And so the court is forced to consider, all right, we've got this offer to think about, we've got this outcome of the litigation to think about. Is this the kind of situation where we might exercise our discretion to, speaking loosely, increase the plaintiff's ordinary cost order, 50, 60, 70% of their costs, up to an indemnity cost order, 85, 90, 95% of their costs, something like that. And so the court turns its mind to the law relating to Calderbank offers. And there are a number of kind of issues here when you think about Calderbank offers. One of them is, did the offeror get a better outcome in the final hearing of the matter than they offered? So one of the analogies I've got is like, hey, I offered to accept 500 grand in my offer. I actually ended up winning $1 million. And so I got a better outcome in the final hearing than in my offer. So that's one of the issues to consider. Another issue to consider is it a genuine compromise? And another issue for the court to consider is, was it reasonable or unreasonable, as it were, for the offeree to reject the offer or allow it to lapse? These are the things turning through the court's mind, we might describe it, as it thinks through the offer that the plaintiff is leaning on. Now, the plaintiff's offer, importantly, was conditional. It's a conditional offer made on the basis of like, hey, here's this offer. In addition to accepting the 1.76 and this piece of litigation being dealt with, also, we're going to deal with these cross claims and we want to deal with these other parties and we want to get out all these other issues here. And so it's conditional. This offer is conditional on these other issues being sorted out as well. And the court says, well, because the issue was conditional, it can't really be thought of as the sort of offer that might found an order of this kind, because it's difficult to say it was unreasonable to allow the defendant to let it lapse, because the defendant actually asks for more detail, says, hey, look, we can't consider the offer in this form. There's too much other moving parts going on, and the plaintiff's lawyers don't actually reply to that issue. So firstly, the court says that conditional issue weighs against an indemnity cost order. Secondly, what the court has to say is, actually, you didn't get a better outcome at final hearing than you offered to accept in this offer. There's this reasonably technical economic loss point that the court has to work through. There's also a calculation of what legal costs had been incurred at the time of the offer. And the court goes through and does its arithmetic and says, well, the offer in this letter is not better than what you got at final hearing. And the third reason the court finds leaning against an indemnity cost order is sort of a lack of clarity, broadly speaking. As I might have hopefully led you to understanding, there's an element where we've got a lot of different parties involved. There's kind of a workers' compensation insurance claim in the background here, and there are a lot of kind of interdependent kind of things relating to the way this offer was made. And because of that, and because the request for clarity made by the defendant sort of goes unanswered by the plaintiff, what the court says is, look, there's a lack of clarity. That also weighs against us making an indemnity cost order. And so, as you might imagine, the plaintiff fails in their application for indemnity costs. Now, what you just heard described was a piece of litigation. And so what about the costs of that argument I just described about costs? Well, the plaintiff lost. And so interestingly, the defendant got its costs of that argument about costs. And I hope that discussion about legal costs didn't blur your brain too much. Really appreciate your company during it and look forward to joining you again soon for another coffee and another case note. Cheers.